Good afternoon, and welcome to the first online lecture in our recently launched Technology and Access to Justice lecture series here at the Legal Innovation Lab at the Faculty of Law of the University of New Brunswick. The lectures are hosted virtually, and we recognize and respectfully acknowledge that the UNB law community gathers at the on the unsurrendered and unceded traditional lands of Wolastoqey. Our laboratory was recently launched, started in January 2023, and is dedicated to the study of law, technology, and access to justice, with a particular focus on access to justice and modernization efforts in New Brunswick. With this lecture series, the lab wishes to promote knowledge exchange between New Brunswickers and experts from other parts of Canada and around the world who work in the technology and access to justice space. I also want to give notice that we're recording the session. Now, it's my great pleasure to introduce our speaker, Professor Emily Taylor Poppe, who will present her recent article, Courts as Data Guardians for the Public Good. The article is published with the University of Toronto Law Journal, and I will be posting the link to the article in the chat. Professor Taylor Poppe is an interdisciplinary empirical scholar whose research is focused on inequalities in access to civil justice. She's a professor of law and professor of sociology by courtesy at UC Irvine. Good morning, Emily, and thank you very much for joining us today.
Good morning. Thank you
Um,
so much for having me.
Of course, and thanks for joining early in the morning. Professor Taylor Poppe investigates the origins of civil legal problems and the paths towards resolution, as well as the role of legal actors and institutions in shaping these processes. And she's also examined how legal education, the relation of the legal profession, legal technology, and institutional design might enhance equality in access to justice. Professor Taylor Poppe serves as the faculty director of the Initiative for Inclusive Civil Justice at UC Irvine. And now with this, I conclude the short introduction. I want to give a warm welcome to everyone. Warm welcome to Emily. Emily, the floor is yours. You have 30 to 35 minutes, and we will then conclude with the Q&A. Thank you.
Excellent. Again, thank you so much for the invitation to be here. I'm really happy to have the chance to share this work. It's always nice when somebody finds an article you've written and thinks there's something to it. So I'm going to draw on this paper, but I'm also going to go a little bit beyond because these are ideas and topics that I'm continuing to think about. So I look forward to the engagement during the Q&A because I'm still researching and writing in these areas and welcome your reactions and thoughts. So I want to start by acknowledging a few priors. So the first is that I love data. This is for those who can't see the caption in the cartoon, the guy runs in and he says, "Better than an answer, I have a tremendous amount of data." And when I saw this cartoon in the New Yorker, I actually did a little sort of spit take because I felt like it hit a little close to home that I may have been accused on occasion of getting a little too excited about data. But I really do believe in the potential for data to help us understand the world, react to the world, improve the world. And so that's really part of what kind of motivates my research and certainly this paper. The other prior is that I think a lot about access to justice. So this is the topic I write about. And I've thought about this from a lot of different perspectives. So I think about the effect of legal representation. I think about how people are able to actuate or use the law differentially. I've thought about institutional design and how maybe that's not really working to promote equality and access to justice. And I've also thought about this link between access to justice and substantive policy priorities. So all of those sort of ideas and themes come out in some way in this paper as I'm thinking about kind of technology, court data, and the potential to enhance access to justice. And then the other big prior is that I spent years collecting court data to study foreclosures in New York City. So, in addition to being a lawyer, I have a PhD in sociology, and my dissertation was about foreclosures in New York City during a little bit before and during the financial crisis and the follow-on foreclosure crisis. So, I collected data on a representative stratified sample of foreclosure cases that were filed in the 5 boroughs of New York City between 2007 and 2015, and then collected the court records and tried to create a data set using those records. So I use throughout this examples from that research to sort of illustrate the points that I want to make about the potential of court data. But of course, I don't think that potential is at all limited to foreclosures. It just happens to be a context that I am very familiar with. So this paper came out of an invitation to participate in a symposium hosted by the University of Toronto Law Journal on modern challenges to the judicial system. And the co-hosts, Anthony Niblett and Albert Yoon, write in the introduction to the symposium that the problems created by the pandemic and the solutions that emerged were the catalyst for us thinking about how courts respond to pressing modern challenges and how they adapt with technological solutions. So this is the context and sort of the prompt that motivated this paper. But what was a little interesting to me in participating in this symposium is that a lot of the other contributors were really thinking about cutting edge artificial intelligence applications to law. And Albert Yoon, for example, helped to co-found Blue Jay Legal. So he's very involved in kind of legal prediction and really sort of cutting edge, exciting stuff in legal technology. And I, meanwhile, come from a world where I'm continually shocked at basic facts we don't have, but could. So I'm sort of, if they're sort of at this high end, cutting edge stuff with massive amounts of data, I'm sort of at the opposite end where it's like we just have basic gaps in our understanding. So, for example, in the United States, how many pro se litigants are there in state court? Don't know. We have some estimates, we have some studies, we have some studies in some states and some courts over some periods of time, but we just don't have national data. I do a lot of research on trusts and estates and the laws of succession and the probate system. How many guardianships are there in California? Don't know. Does the probate system work? For whom? How well is it working? Where are the pressure points where it's not working well? When did debt cases take over the state court docket? We know that in the US now, in state courts, debt cases comprise about a third of case filings, in some cases, closer to 50% in some states. When did that happen? How did that happen? What was that evolution like? The eviction rate, does it vary? Does it vary by space and place over time? How? Why? We're starting to get some information on those questions as a result of big court data collection efforts, but that's not something we've known in the past. And all of this pushes me to start to think too about what interventions work best to help people who are appearing pro se. Because certainly in our state courts, that is increasingly becoming the dominant position of people who are appearing in courts. So in the paper, I really push 3 big points. The first is that I really want to emphasize the potential of court data. And I want to be clear on a couple of things. First, when I'm talking about court data, I'm not just talking about filing rates. So we have pretty good data in a lot of states about sort of what's being filed and then ultimately when it's being disposed. And in some contexts, we also can get docket data where we start to see the life course of civil litigation. Um, but I'm actually going even further into the actual court records because that is where the really cool stuff is happening and where a ton of information is stored that's not really being used to its full potential. So I want to be clear first that when I say court data, that's a pretty expansive definition of court data. The second is that I want to emphasize that I think court data has potential to help the courts, but also to help other branches of government and to benefit the public. So in this paper, that's one of the big arguments I wanted to put forward was to emphasize that court data is valuable not just to courts, but to these other parties. And that in recognizing that, it can help shift our thinking about the value of court data and how we use court data, and why it's such an important resource. So, to emphasize and kind of illustrate some of these potential benefits of court data, I have a number of examples. So, the first is the possibility for court data to improve court management, so staffing, budgeting, operations. And in the paper, I draw on a quote making exactly the same point, talking about the exciting advances in technology that the Fortran system represented. Fortran was the initial digitization of court data in the federal US court system. And we're talking like big mainframe computers. And I did the work to figure out that those computers basically have less computing power than an Apple Watch. So today we have massively more information and massively greater ability to use that information. But the idea is similar over time that we could use it to improve staffing decisions, budgeting decisions, operation decisions within courts. And to give an example of this from the foreclosure context, the red line here on this figure is representing foreclosure filings in New York State over time between 2000 and 2014. And what you see is you start to see this huge run up in foreclosure filings around 2006, 2007. When we start to have the subprime mortgage crisis, there's huge levels of default. And so in New York State, it's a judicial foreclosure process. So this shows up in court. What we also had during that run up, if you remember, was a lot of problematic behavior on the part of lenders. First, we had problematic behavior in terms of lending in the first place, but then also we had problems with tracking ownership of mortgages over time as they were transferred, especially as they were securitized. There was a lot of lost paper. And then we had a lot of foreclosure cases that were being filed with robo-signing, where one lawyer was signing hundreds of cases a day. And what they were essentially doing, they should have been doing when they were signing those, is they should have been attesting to the fact that the lender, in fact, owned the security interest and was able to move forward. That isn't really what was happening. And New York State imposed an affirmation requirement requiring that lawyers actually sign this additional affirmation saying that they had reviewed the documents and there was in fact evidence of ownership of the loan. And so we see a huge drop off, right, in filings in response to that. And then what ended up happening after that was the rise of a huge shadow docket. So what happened is that lenders then began filing foreclosure cases, the original complaint for foreclosure, but they didn't file the request for judicial intervention, which typically should have been filed at the same time. The request for judicial intervention was the procedural mechanism to allow courts to begin taking action on that foreclosure case. So without filing that, courts couldn't move forward and set a settlement conference. They couldn't push the cases forward. So at first, it took a while to realize this was happening. And then once they did realize, they were able to pass legislation that addressed this issue. And they also could dedicate staff to going back through that shadow docket and addressing it, which was important both for kind of the court's docket management, but also for the people involved, because homeowners were stuck in this limbo where it wasn't exactly clear if the foreclosure process was moving forward or not. And so that's just an example of how understanding what was happening by using data that the court already had was a way that they could improve and respond to an issue that was going on in the court. Another benefit of court data that I talk about in the paper is the ability to use court data to assess procedural interventions. So again, in this foreclosure context, one of the major problems was that homeowners defaulted at very high rates, even when there was a chance that defenses were available or when it was possible that they could have arranged a more beneficial outcome than a foreclosure, so a short sale or a loan modification. And so it was concerning that homeowners just were not appearing in court. So within my sample of cases, I found that 76% of homeowners did not file an answer. And so the court wanted to do something to affect this. So what they did is they imposed mandatory settlement conferences. And these settlement conferences required that the homeowner appear, but also that the lender appear, and that the lender appear with authority to negotiate a loan modification or short sale or an other alternative to foreclosure if that was appropriate in this situation. So my dissertation was set up to study the effects of lawyers. So I really wanted to look at what homeowners got lawyers, and then given who had lawyers, what difference did it make? And the somewhat disappointing thing I discovered is that this settlement conference was more important than having a lawyer. The imposition of this settlement conference was actually a better predictor of avoiding foreclosure than legal representation, which is why I guess you can't get too um, in love with your hypotheses, because sometimes they turn out not to be what you expect. So it's only really, though, by having a data set that collected information on the filing, the characteristics of the loan, the characteristics of the lender, the characteristics of the homeowner's behavior within the process, the presence or absence of a lawyer. I needed all of that information to be able to kind of do this analysis and find this result. And that requires getting data out of court records. So again, this huge potential, but it does require digging in to be able to get a lot of information. Another potential benefit of extracting and analyzing court data is that it can allow us to identify abusive litigation or problematic litigation behaviors. In the foreclosure context in New York City during this time period, one firm, the Stephen J. Baum firm, represented the plaintiff in about a third of all of these filings, which would be fine. It'd be interesting, but fine if we felt that that firm was behaving appropriately. Instead, that firm was sued by the Attorney General for filing false pleadings, misleading pleadings. There was a lot of really problematic behavior undertaken by that firm, which eventually went out of business, especially after there was an expose about the people who worked at the firm mocking homeowners who were in foreclosure. So again, under having data and using the data allows us to see that, and then can trigger enforcement behavior by other parties. It clues us in to things that we want to pay attention to, and that other people, in this case, the Attorney General, beyond the court system, care about. Another big potential that I see, and this is moving a little bit beyond courts, is the potential for court data to be used to understand policy efficacy, policy uptake, and policy efficacy. And here I'm moving beyond courts and talking about the benefit of court data to other branches of government. So in this foreclosure context, within the data that I compiled, 20% of the cases went to foreclosure, 16% were ongoing at the time I ended my data collection and decided to move on with my life. 64% were discontinued, almost all without prejudice. And 35% within that 64%, but 35% overall were settled through some type of loan modification, short sale, that the loan was satisfied. And so if you really dig into those cases, you can start to see the extent to which loan modification programs were having an effect on foreclosure actions. So during this time period, the federal government provided several loan modification incentive programs that were designed to help encourage lenders to create loan modifications. And in case there are any economists on the call who I always, get questions about this, avoiding foreclosure is actually usually economically superior to lenders as well as to homeowners. They lose money very often on foreclosures, whereas short sales and loan modifications can be a better result. So this is just one example, but there are many, many other substantive policies where some piece of that policy touches the civil justice system. Either there's an appeal from that policy, a denial of benefits, for example, gets appealed, or we can see in other ways places where those policies touch the civil justice system. So court data is another sort of policy feedback mechanism. And then, despite what the executive branch of the United States might think about this point, I continue to think it's very important that we understand distributive consequences of government action. And that I think most courts care about equal protection under the law, and they want to know who they're serving and how well they're serving them. So, again, in the foreclosure context, this is a map where I've mapped the locations of all the foreclosure, the properties that were being foreclosed in all the cases that I was studying. And then I've set that against the proportion of the population in that area that's Black. And this is really consistent. We find clustering of these foreclosures. And in fact, there was tons of research done by social scientists, economists, political scientists, legal scholars about lending patterns leading up to the foreclosure crisis, patterns in foreclosure initiation, homeowner responses to that foreclosure initiation, and foreclosure outcomes. All of those raise questions about equality under the law. And we couldn't see it without collecting information. So this is one other complement to information from banks about lending practices. The HMDA data, Home Mortgage Disclosure Act, requires data. But this is one other piece, is again a place where court data can be used to help us understand sort of inequalities in how people are navigating legal processes, how those legal processes are affecting them, and also kind of how other policies are playing out within the context of courts. And then the last point I make in the paper about the potential benefit of court data is its potential to democratize legal analytics. So when I wanted to undertake this project, I realized that the problem I had was that there was no way to identify foreclosure cases. The New York State court system remedied that after my research was underway, and now there is a way to identify foreclosure cases. But when this began, there was no way on a kind of a civil case cover sheet filing. There was no way in the case numbering system. There was just no way to identify foreclosure actions as opposed to any other type of case. And so basically collecting the sample of cases to study was impossible. It was incredibly difficult. You would have to just sort through tons and tons and kind of find the foreclosure hits. The way that I was able to collect the sample was by using data from the property records, where there's a lease pendens that has to be filed before the foreclosure action can begin. So it's notice in the land records that the property is subject to litigation. But even then, I couldn't just go to the clerk of the counties to understand from the land records where these lease pendants had been filed. Instead, a private company, Realty Track, had an army of data collectors who went to these county clerks and hoovered up all the data and then sold it, packaged it, bundled, made it into an actual data set. And that data is incredibly expensive, and I would never have been able to get it, but for somebody else, another researcher having a large grant who was able to buy the data, and I was able to become part of that grant and use the data to collect my sample. And I'm going to talk more about this in a moment, but part of what this gets at is this growing divide between the public world of data analytics and the private for-profit world of data analytics. Um, by having courts move into this space, we could democratize the accessibility of this type of information, and we could democratize the potential to be doing more sophisticated legal analytics. So, of course, we're not really there. um, it's better in a lot of places over time. And so when I wanted to do this and collect this data, it really varied across the 5 counties. Some counties did have digital records. I was able to get PDFs of documents. In other places, I had to get paper versions. And um, it was massively time consuming, massively expensive. In some cases, I had to get an NSF grant to be able to afford to do this. And so this was literally like, courthouse basements pulling paper files. And even where we had records, they were PDFs of messy documents. And so I had to, in some cases, they wouldn't always give me those digital records because in order for them to get their 10 cents per page fee, you had to print them. So I had an RA who went to the courthouse, went to their computer, printed out all the records, paying the 10 cents per page so that I could bring them back to my office and scan them and OCR them to create a database, which is not a very efficient workflow. Um, and the level of analytics that most courts are engaged in, is pretty basic. So this is just an example of kind of court filings over time by different types of cases. This is sort of the type of court data that we often get publicly, is pretty basic kind of counts of cases coming in, cases going out. Um, and meanwhile, there's a whole lot of stuff happening in the private sector. And that's facilitating both its private enterprise undertaking huge data collection efforts, so pulling all this court data, then turning it into usable databases, and then from that engaging in higher level kind of legal analytics. So there is this growing divide between what's happening in the private sector and what's happening in the public sector. So, second question, how can we harness this potential of court data? In the paper, um, I argue, and this paper was written, came out in 2023, and every day there are new advances. So that's even sort of before Chat GPT and sort of our attention to even newer kind of large language models and new technologies. But I think we are at a moment where there is possibility. So, this increasing digitization of court records makes court data more accessible, more usable, and also new technology that lets us extract information from court records without human involvement. So when I did my project, it was still very analog, human undergraduate RAs entering stuff into a spreadsheet extracted from the documents. But now, with AI, you could actually be doing a lot of that scraping and pulling out in an automated way. So the potential for using data and collecting data and making it usable is just growing all the time. And so what that asks of courts then is to think about how can data be made more usable? How can data be shared? And to what extent can courts engage in analytics using the data that is now more accessible and more available? And that's where the paper gets a little theoretical. So, walk with me a little bit. Um, but I use the idea of a boundary object, which is a concept that Susan Starr created and used in her work. And what it really gets at is that very often in the world, we have objects that serve multiple audiences. So often she gives the example of a map, and we could think about kind of the layers of information that are included within a map. And yet, the format of a map, in order to be legible to the many different audiences who you want to use it in different ways, has to have some standardized formatting. And so what she gets at is that these boundary objects serve many different groups, but that through an iterative process, we agree across these groups on sort of the format and the content of these objects so that they can be useful to these many groups. And so building on the first section of the paper, where I talk about the potential of court data for a lot of different audiences, I wanted to step back and think about court records from this boundary perspective object. And so the point is that within an individual case, a court record is important for litigants, right? We understand that as lawyers, right, we all immediately think about, okay, well, what are the claims and what are the elements of the claim and what are the evidence that's being presented in favor of those, or what are the legal arguments that are being made? I teach civil procedure every year. What is the purpose of a complaint? To give notice to the defendant of what they have to respond to. Um, Obviously, this is all really important for judges too. Like the content of what's contained within pleadings and court records, really important for judges. But then we also think about clerks, right? So clerks are responsible not just for maintaining those records, and so they have to understand kind of filing, service, distribution, but also it connects to things in the real world. So courtroom space, docket space, assignment across judges, court resources, and how those are used. And so you start to see that pleadings and other court records have these purposes far beyond just sort of their narrow legal definitions. And then beyond that, when we think about aggregating these court records, they're also useful, valuable, informational for other parties. What's happened in similar cases, right? One, obviously, that's important for precedent, but also now with legal analytics, we can start to think about what arguments are more effective in front of given judges, what arguments are more or less used in certain consequences. What settlements were reached? What is a reasonable settlement in a situation like this? Other court actors, right? And then also thinking beyond that, also to policymakers. So, for example, this idea of understanding how outside substantive policies are playing out within the court system, suddenly policymakers are also a potentially interested party in this data. So, if we think about these many layers and many users and the many pieces of information that are contained within court records, what I start to think about or push toward in the paper is that we have a potential to really rethink court documents. So, right, we're path dependent. We are coming out of history. We know that the form of pleadings comes from an analog era. We see this as lawyers. Here comes the plaintiff. Wherefore we ask for, right? And so we're very much kind of coming to this very often from this analog world where we're thinking about paper documents, we're thinking about historical pleading practices. But if we reinvent that, and as courts move toward thinking about online dispute resolution, or at least electronic elements within a standard civil litigation process, we could instead really think about court records as digital data. And that could have really different consequences for how we think about what these things look like, how they're created, how they're transmitted. And so a lot of places are working about, in the access to justice space, moving toward thinking about guided forms to help pro se litigants be able to tell their story. As we start to move toward, could AI help to create a narrative that gets put into a document? Well, could pieces of that information also be pulled out digitally so that we're geocoding automatically, we're using addresses in an automatic way, we're collecting information about litigants in an automatic way? This is the part of the paper that's a little bit blue sky, kind of dreaming, but also I think that's useful in kind of thinking about how do we move into the world of sort of online courts and online pieces of litigation. And then the last part of the paper gets to this idea of, okay, so why should courts be doing this, right? I've already pointed out that private industry is moving into this space, right? We have private companies that are collecting court records and turning them into usable data. Why should courts do this? And here, I think there are 3 points that are important. One is that courts represent a public option, and public options are appropriate when we need to fill gaps in the market, when we have areas where the market is not going to serve. And so again, if my prior is I'm coming from the access to justice space where I'm thinking about largely unrepresented litigants, there is unlikely to be a private for-profit um, response to many of the needs of that group. And I think courts could serve as that public option. I also think it's important to remember that courts have a different orientation because they have this public service mission than for-profit companies. So a for-profit company might not care about evaluating the effect of policy interventions or procedural mechanisms, but courts do. Courts have a different set of priorities and relevant questions. And so, again, I think there's sort of a gap-filling piece here. And I also think that service provision standards have increased. And what I mean here is that if we look at this from the perspective of people using courts, they're using lots of other services too, right? So for example, I pay my electric bill online. I have an account with the public utility provider. On that account, I can make payments. I can see what's happening, my usage over time. I'm used to an online world where information is available, information is customized to my situation. I can make payments easily. I can communicate back and forth. So if we just think about the world that people are living in and what their expectations are for the service that's provided to them, I think it allows a lot of these things to fall within an existing service mandate for courts. So, for example, another piece of this is that any retailer today has incredible amounts of information about shopping habits. And if they're an online retailer, we all know they have scary amounts of information about our browsing habits, our search habits, our shopping habits, right? And so the level of information that other private companies are working for in providing service is just worlds different than sort of what we think about from a court's perspective. But I think making this argument helps courts make the argument that they need the resources to be able to better serve the people who use them. And so I think this is actually a way for courts to make arguments about, from a customer service perspective, why this stuff is within their realm. Okay, so I'm sure that there might be some court people on the call who are, it's not that simple, and I 100% recognize that. I get to be the academic who has the big ideas, but I recognize that putting those big ideas into practice in the real world is not so easy. First, there's a challenge, and I talk about this in the paper, of is this stuff within a court's mandate, right? So in order to think about how to really move into the world of legal analytics and more sophisticated data collection and data management, right? In some cases involves an expanded role and an expanded conceptualization of what administering justice looks like. And it's one that's kind of based in reality of what's happening in the world, as opposed to our sort of idealized view of courts as sort of staid institutions that just sort of respond to what comes to them. So I recognize that there can be tensions or perceived tensions with what actually is the mandate of courts relative to other branches. I think privacy, too, is not something that can be completely ignored. Yes, court records are public records. So to some extent, I think a lot of those issues are resolved. But there is a difference between a record that's available if you go to the courthouse basement and a record that's available online easily and large data sets. And I think certainly in the US in the current moment, there's a lot of thought about data, and data can be used by different parties for different purposes. And so recognizing those challenges. So one, thinking about sort of interbranch data sharing and the challenges when I talk about kind of using court data for policy versions, and also just civil court data flows. There's a huge record on criminal records and how they can be used and misused. The same things apply in the civil context. So I'm mindful of privacy issues. Although I also think these are public records and they are already being used by private companies in ways that can be concerning. So I'm not always sure that privacy is a reason not to move in this space. And then I also want to acknowledge the practical realities. Institutional design issues, incentives, resource constraints, obviously huge, right? Courts can't do this if they don't have the funding to do it, if they don't have the personnel to do it, if they don't have the staffing, if they don't have the technology. And I also want to acknowledge that I tell a really rosy story about court data, but court data can also be messy, incomplete. There are key variables we want to have that aren't there. So I don't want to be too Pollyanna-ish too, and about the potential of court data. And yet, I'm that data person who really believes there is this potential. And I really would love courts to be supported in moving into this space and taking advantage of the opportunities that are presented by new technology and by digitization to really think about how we can use data for the public good. Um, and with that, I will stop sharing and welcome your Q&A and the conversation.
Wonderful. Thank you so much, Emily. There's a lot to think about, and I will give everyone a second to collect their thoughts and come forward with questions. In the meantime, I promised I will add the link to the paper. It's now in the chat. Please raise your hand digitally. I would invite you to turn your camera on if you're comfortable with that and pose questions directly to our speaker. And we will start with Kyle Cudlem. Kyle, floor is yours.
Yeah, so just a general question in terms of the accessibility of data from the courts. Um, yeah, in general, you want your justice system to function so that decisions are made based on the facts and based on the law, and that's what gives people confidence that it's working properly. Would you expect any hesitancy from courts in using data or making it more easily accessible publicly based on the risk that people will perceive decisions being made um, based on things other than the facts in the law? So, for example, if, well, one judge is more lenient in terms of, say, late filing or something like that, or another judge is more harsh on the admissibility of evidence or whatever, things like that. Do you think that there would be some pushback in terms of just trying to preserve the confidence in the justice system based on these variations that might not be so obvious to people?
Yeah, it's a great question. Certainly, I think that's happened already in terms of how courts feel about providing judge information. So I talk in the paper about France has actually said they're not going to, the French court system doesn't want to provide information because we don't want to see this variation across judges. And so I think there is reason to be sensitive, and especially at a moment when the legitimacy of institutions, including courts, is under question. I think that is a concern or a sensitivity. On the other hand, I also think that we don't improve things by just leaving the rock. Sunlight is the best antiseptic, right? And so if we just don't turn over the rock and just don't see it, it doesn't mean it's not happening or it doesn't mean it's not there. Um, I also think it's really sort of fascinating the comparison between the criminal justice system and the civil justice system, and that there's been so much attention to the criminal justice system and its flaws, rightly so, and its challenges. And in a lot of ways, the civil justice system, it just sort of it just doesn't attract the same attention. And so maybe that's I don't know if that's a plus or a minus, right? Maybe the concern for courts would be that if you start to make more of this stuff accessible, it attracts the same types of critiques. Um, but I also think it presents opportunity to address problems that you identify. So I think it's a fair concern. Um, but I guess ultimately, at the end of the day, I'm trying to get us toward a better system. And I think acknowledging challenges is part of that. And I just think hiding it, trying to hide it is not the best approach.
Jacob? Jake.
Hi, thanks for the great presentation. I found the idea of boundary objects really fascinating. Um, but I'm also wondering about if you could elaborate a little bit more about the privacy concerns, because it's something that I've been thinking about, related to technology and artificial intelligence in particular. Um, and I wonder if you have an idea of how both uh, this kind of public use of data and private use of data could be kind of, I don't know, regulated so that there isn't a danger of, for example, AI inferencing very private information about people who have their information in the court system. Um, because I think often people come into the justice system without their own consent in a way. Like they find themselves there. It's not like they were like going on Amazon to go shopping.
Right.
Yeah.
Yeah, I think it's a great question. I think that one, it is important to recognize that it's already happening. So in some sense, the horse is out of the barn, the cat's out of the bag, right? Like, so for example, bankruptcy filings are already, there's a private industry of taking bankruptcy filings and then selling information about who's been subject to bankruptcy to private users who want to use that as a proxy for all kinds of things. So one, that doesn't mean it's right. It doesn't resolve the issue, but it just says, one, we have to recognize that this already happens on the private side. And so the court system not doing it doesn't prevent it from happening. I think the other thing is that there can be ways to think about anonymizing data. So, if the court wants to make a data set that's available about what's happening in eviction courts or patterns, they can also provide data that's anonymized. You don't have to give names. You can give, just you can anonymize data sets. So if we want to kind of go part of the way of providing kind of usable data, but not, deal with kind of the privacy pieces, you can, I think there are ways to do that. And especially when we start thinking about kind of data merging and data sharing across agencies or data sharing across branches or data sharing. I think we have ways to do that can anonymize data and make it can resolve some of the worst of those concerns. And I think the sensitivity to the point you raise, which is that should we treat people who are brought into the court system as defendants, for example, in an eviction action, are different than somebody who is filing a claim. Maybe or maybe not. I don't know that you're right. They haven't consented. They haven't agreed to participate. But I also think it's hard to kind of make the distinction on those, to say we're going to let information about plaintiffs but not defendants. I think that one's challenging, but I think sensitivity to the point is important. And so I think trying to find workable compromises is sort of where I come down on it. But it's a challenge, and I don't have all the answers.
Next is, I think, Lucy Giebel.
Yes, hi. Very interesting presentation, and there are many aspects of the presentation with which I fully agree. I think there is a wealth of information in the court documents that we should exploit for the better purposes of policy making and improving. I mean, there's so much information that we should be able to access just in terms of all the courts litigations that don't make it to final decision. I mean, most cases, I think, never make it to a final decision, and we often wonder what happened in the meantime. And I think collecting that data would be very, very enlightening. I do share the concerns about privacy, and you've answered very nicely and convincingly, but I would suggest that it might be informed by your jurisdiction. Um, that looking at other jurisdictions in the world, in Europe or even Canada, I think that the sensitivity to privacy is higher.
Mm.
And that there would be greater care probably in merging private information into big data sets and also reusing those. And anonymization may be one way around it, but it may not necessarily work all the time. And, even there are so many areas of policymaking that would benefit from an in-depth search of court documents, not just financial or real estate, but also family matters, for example. And if there's one area where privacy concerns are very high, that's there. So this may not be a question, but it's certainly to exchange the views, although also related but not discussed in your presentation. I also think that copyright might play a role, and it might play a role differently depending on the jurisdiction. Because court documents, if they're an expression of ideas, they might be copyright protected. And maybe under US law, it might be just, fair use to reproduce and harvest all the data in those documents, but it may not be recognized everywhere. So just and one last remark. You might want to look at the Federal Court of Canada, which has an electronic filing system. And I don't know if you're aware of this, but at least everything seems to be digitized in terms of processes at the Federal Court of Canada, which is not the common law courts. It has, specific areas of jurisdiction, but it might be interesting.
And these are great. Thank you. So, in the federal, I will definitely look into it. In the US, in the federal courts, it's all digitized and there's a lovely data set, Pacer, but it's expensive and it's behind a paywall. And so the ongoing fight is about free Pacer and to make this stuff accessible and not so expensive. And there's a lot of question about the incentives behind the costs of accessing public data through Pacer. So, yes. And I think your point about copyright is also interesting. And I think it also plays into what's happening with AI. And if I use this corpus of court filings and I use it to then through AI, I have AI drafting complaints. Now I'm, working on the backs of lawyers who drafted all these complaints. I think if we can't protect artists, I don't know that protecting the intellectual property of lawyers is gonna. So I'm a little skeptical that it's going to be a huge obstacle, but it is an issue, right? And you're right that there is labor that is behind those drafted things, and so it's a great point. And I think the comparative perspective on privacy is also really interesting. And I think you're right that I am probably influenced by living in a world where there is, in a jurisdiction where there is remarkably little protection or respect for certainly consumer privacy. On that point, I'll just raise one other note, which is that I was at a conference last year, and a researcher, Catherine Young, was talking about a focus group. She's been doing this long-term qualitative project on people's engagement with the civil legal system. And the issue of privacy came up. And she was saying, what's fascinating in my focus groups, in my interviews and discussion with people, is that they're actually really mad that the court system doesn't share information with other agencies. Or, for example, my interaction with Medicaid, I'm really annoyed that Medicaid doesn't share information with other, like SNAP, like other benefits. And people expect that the government is already doing this. And they're actually more annoyed that they're not, and they're having to provide the same information over and over. And that they talk about the types of privacy they talk about is that they don't want their neighbor to know their business, but they're not concerned about the government knowing their business because they actually assume it already does.
May I react shortly? Just quickly to say in certain jurisdictions in Europe, like the Netherlands and in Germany, for example, court decisions are anonymized, but the level of integration of all government system is very high. And when you join, I mean, when you give consent to the government to collect in one area, you're also asked to give consent to that the government will share with other instances. So one does not exclude the other, but the final output of a court decision in the Netherlands and Germany, they're all anonymized.
That's fascinating. Thank you. And I think that that's a fascinating, comparative analysis there.
Fantastic. And Christian Wallen has another question.
Right. Thank you, Marguerite. Emily, thank you so much for the presentation. I'm with the Public Trustee's Office here in New Brunswick, and I was very interested in your presentation. I feel your pain. A few years ago, I remember having articling students go to, court offices in different jurisdictions in the province here to pore over family court records to try to find information with respect to, family court files where children or minors had received the benefit of independent legal counsel. And, that was the issue we were looking for, but there was no way, of, analyzing from, the case reports or available data, what those cases were, where children had the benefit of independent counsel. So you had to go looking for the needle through the haystack. And I'm interested that, in the list of sort of, next cases that you thought would be interesting, to look into is, that evaluation of the value added of probate court services. And that's a little bit closer to my bailiwick now. And I'm wondering if in your readings you've had a sense of, where are the jurisdictions, stateside or globally that are really practice leaders, in this field, and is there, it's a little bit like how do you go about the task? I recognize, that challenge of the independence of the judiciary, and then, if this is going to be done, then here in New Brunswick, court services within the Department of Justice, would be the natural leader, but they're part of the executive, and so you need that collaboration. Are there, are there thoughts that in swallowing this elephant, that it's good to kind of parse off little bits, and like, could we talk about starting with a probate court project, or have you seen practice emerging that's like more targeted as a pilot of this kind of reform?
Yeah, great questions. And yes, I can totally imagine what digging through that haystack looked like. I would say in the US, we often talk about that there are these one-offs, but we often see it, we talk about it as a frustration. And largely the frustration is that all our state courts are all their own system. And then even within every state, there can be multiple different courts, and the courts are not all arranged in the same way. Their funding streams are not all the same. And so the incentive structures can be different. And then the other piece that comes into play is the use of private online platforms. So in the US, there is one company that shall not be named that serves a lot of these courts. And there are also issues with the arrangements made between these courts and these private platform providers about who owns the data, how the data can be used, how the data can be accessed. And so part of the problem has been if people on the outside want to develop tech innovations, whether they're interventions to assist pro se litigants or they're interventions that could be used to help courts, they have to be customized to every jurisdiction. And so it really prevents scalability. So I think, yes, there are these pilots, but we often talk about the fact that we start with sort of the pilots is the result of a frustration that then we can't always scale the pilot because moving across jurisdictions is so difficult. And so there's a big project at Stanford right now through the Rhodey Center and the Legal Design Lab, Margaret Hagan's lab. They've been working on trying to come up with ways that they could try to create tech systems this is more intervention aimed at both kind of less on data and more kind of intervention for assisting people, but trying to tackle this of like, how can we scale this sort of from the outside? In terms of court leaders, I don't know that there's big variation across states. So I spent a bunch of time trying to think about a probate court project where I would pull probate court records and then be able to kind of understand what's happening in probate courts and what's working, where the sticky points are, what takes a long time, what doesn't, who's using it, who doesn't. And it was just fascinating to me, the work it took to try to figure out which states have digitized those records, which states those records are accessible, in which states are those records not accessible because of privacy concerns. So probate or guardianship different than other types of civil cases. And I ended up zeroing in on Connecticut as a leader in kind of court record stuff, Florida as a leader, but it's hugely variable. In terms of other kind of pilot programs to try to do stuff, I would also say the National Center for State Courts, and in particular, Zach Zarnow, who's the director of their Access to Justice initiative, has been a really amazing resource for me. I learned so much from Zach. So I would also put the National Center for State Courts as a resource for people thinking about this, because they've created a framework for courts to use in entering into agreements with private platform providers as they start to move to digitize. And they've provided a lot of other framework and helpful information for thinking about kind of moving in this direction. So I would sort of point not to me so much, but as to the National Center for State Courts has a lot of resources sort of on that front.
Fantastic. We are 3 minutes over. I want to very quickly note that similar guidelines are also found in the Canadian Judicial Council. As you were presenting, as you were speaking, I was thinking about the definitions of court data as an umbrella term, and then judicial data, and all the different types of and categories of data that could help courts systematize, think about their data management practices, etc. So the Canadian Judicial Council has been quite active lately with a number of very useful policy guidelines, policy models that could be a good starting point, especially for Canadian institutions and others. So I wanted to add that very quickly. I have so many questions that I will have to keep for another chance, because I want to make sure that everyone can go to their next appointments. Is there any last comment that you, Emily, want to share?
I'll just say thank you so much. And I'll also flag that Aguirre and I met at the International Access to Justice Forum, which will take place this year in late September in New York City. So if you're fascinated by this kind of stuff, I'll just flag that as another another point of community.
Fantastic. Thank you. Thank you so much. Thanks for the wonderful talk, and thanks everyone for joining and for the great questions.